Well, thank you so much for having me here today. It's always a pleasure to meet fellow Emerita faculty. So, yes, I am an Emerita faculty from the law school where I'm still teaching. And I also am the director of the campus mediation program for the university. So, those things are very busy. But when I was asked to speak, I said, well, what would be a good. And I thought maybe you might be interested in seeing what's going on at the law school in terms of scholarship. And the reason is because most people think of law professors as doing, esoteric, long 400-foot scholarship that only is read by other law professors. But in fact, nothing could be further from the truth, as I hope you'll see. So, my colleagues and I are actually doing a wide variety of research, some empirical research, which again is something that's not very common among law faculties, and even books for the podcast published by Simon & Schuster, and a lot of public-facing scholarship having to do with community engagement. So I'm hoping that you can appreciate then a quick view of some of the things that my colleagues are doing. So first is Ryan Kopis. Ryan is a fairly new addition to our faculty. And in addition to his law degree, Ryan is also an empiricist. And so here I focused on two of his research projects. One has to do with the question of whether or not in a federal lawsuit, whether the race or gender of the judge makes a difference. And the held is that women and judges of color were more likely to issue rulings that would be considered liberal. Basically, Ryan undertook this study, a huge study, 2,000 cases he evaluated by 545 judges, rights cases. And interestingly enough, race or gender, but the distinction based on who appointed the judges. So if we had, for instance, Democratic presidents, because federal judges are all appointed by presidents, then we saw no difference in the women of color or women or judges of color. The Republicans, however, the Republican appointed justices did in fact, we did see a difference with the actually the race and gender predicting more conservative outcomes. And the lie really the ongoing thought about what would happen in these particular cases. And so the second has to do with parole decisions. And he thought with the idea that parole in appropriate circumstances is a very good thing for society. It's crowding, it allows people to have an opportunity, society. And so in this case, he focused on the New York parole. What he did was he basically, again, using these algorithms, he could actually predict. So based on, for instance, the person's past history, he could predict whether or not that person would be likely to commit a crime in the future if actually released. And what he found was that the parole board first could actually have granted twice as many paroles as increasing the risk to policy. So again, really important research to the public good, to the knowledge. Our next one is Jasmine Khalid. And Jasmine is our copyright professor. And Jasmine was particularly interested in this law, which Visual Artist Rights Act, and it has to do with the oral rights of artists. And so basically the idea is that it gives the artist the right and the use of his or her name on unauthorized works of art, and also to prevent the use of the name of the artist on any image that's been distorted or mutilated or modified in a way that would be prejudicial to the reputation of that artist. And that's what the idea of moral rights. And so Jasmine is particularly interested in how wide this protection is and what does it cover. And historically, it was limited to paintings, drawings, prints, sculptures, or still photographic images, what we would think of as traditional art. But Jasmine, looking at some recent, asking a question about what about the non-traditional, like graffiti? So we see some courts now moving in that direction. And she's also interested too on, what is the impact, particularly the discriminatory impact when you are not including artists like those that do graffiti. What is that? What's the social impact? That's what Jasmine is up. Yes, of course.
Yeah, in the back.
Yes.
Elements have basic images generally. So I'm wondering if her work or how this might, or what your thoughts are in terms of how. I had an example in Congress recently where they had artificial intelligence that had studied his writing. Well, he then had an artificial 30-minute presentation that was totally built on this. I never said a word. And so, so in art, we have a similar situation with mimicking this. Any thoughts on how that's going to play out?
I don't know, although one of our other faculty members, and which was later on in the presentation, actually is our AI expert. And he is also our librarian, Paulister. And so that is his area, and it's been very fascinating that something similar to what you're saying is at the intersection of legal practice and education, of course, is a law school. So in legal practice, we have recently a lawyer that was sanctioned for handing in a brief that had a list of cases that didn't exist. And when brought to his attention, that in fact it was AI generated. And so of course he faced sanctions, as you can imagine. And so then of course, so that's the legal practice side. And then of course in education, the curators have just passed a rule now outlining the use of AI unless specifically allowed by an instructor. And so we see then basically the melding of legal practice and education at a law school. And that's where we rely on Professor Paulister for those kinds of issues. And I'm sure that Jasmine would be interested in that as well. I find particularly interesting. And this is, so Patrick Breyer is one of our, but this particular piece, basically the story he's telling is of Josephine Baker. So Josephine Baker, in 1952, came back to her hometown of St. Louis. And she was there to do a performance to raise money for the underfunded and segregated Black neighborhood schools in St. Louis. And it was an extravagant celebration, dancing, singing to a diverse group of concert goers about America's violent racism. And basically, she introduced many of the beliefs that now form modern legal theorist idea about, for instance, critical race theory. And so in this particular instance, what Professor Breyer has done is he basically, with a group of performers, put together a performance that has a narrative. And he wrote the narrative as though it was Josephine Baker telling the story. And then it's performed. They got funding to perform it. with, singers and dancers, and then have this narrative. So again, not at all what you would think. Back to, again, this one question of the background of Brown versus Board of Education and of critical race theory, which is based a lot on narrative. Okay? Then we have Paul Paulister, and this is the guy. This is our AI guy. And so Paul is our librarian. His most recent work has to do with what we call treatises. And so treatises are just basically what we call horn books, or a statement of the law, the history of the law and what the law currently is. Not what it should be, but what it currently is. And there's a lot of theory that this is old-fashioned, and we shouldn't be relying on these books that, again, are kept up to date, but again, not predictive. So he went ahead and we looked at case law, and we looked at briefs, and we looked to see, are these treatises still being cited as authoritative? And in fact, we found that they are. So that's the persistent thesis. And they're stabilizing, he thinks, in terms of the rule of law, because they actually, again, they show the history, they show what currently it is, and not predict what it will be. Which is so much of what lawyers are doing, is trying to convince judges to change the law or legislators to change the law. So that is that's the persistent thesis. And then again, research, and he's completing the second article on the topic. So there's a lot of talk over email. And then Dan Weddle is our professor who teaches education law. And his work is also very interesting because, first of all, he is writing with John Tinker. John Tinker was the plaintiff in probably the most famous First Amendment case involving high school students and First Amendment rights. And Tinker versus Des Moines, Iowa School District, there were a group of students who wanted to wear black armbands to school to protest the Vietnam War. They were suspended from school for this action, and then brought a suit in federal court that eventually ended up. And in that case, the Supreme Court found for the plaintiffs, for the students, and said that students don't shed their First Amendment rights at the schoolhouse gates. So it is the most prominent of those cases. Since that time, the Supreme Court has clearly moved to the right and away from the protection of student rights and much more into the protection of school safety, etc., after Columbine, lots of different issues. But a particular interest now for Professor Weddle, writing again with John Tinker, is this whole idea of banning books and banning topics. And so their argument is that schools should be a marketplace of ideas. And if we are restricting what students can read, what topics, in school, we're not preparing them in the way that public education should prepare a student for their life now, in particular their life after graduation, when clearly they're going to encounter all of these different ideas that are now thought to be banned for one reason or another. Our next is Jeff Thomas, and Jeff also is one of our associate deans. His area of interest is insurance law. So he was looking at business interruption insurance. So a business person will have insurance against, for instance, a hurricane damaging their business when they have to interrupt their business because of a natural disaster or a riot or some other cause. So he was looking at it, particularly in the area of the pandemic. Needless to say, many businesses lost money because of the pandemic. But what he found was interesting, again, using an empirical database, is that the courts were becoming more and more hostile to these claims. Because when the insurance company doesn't pay, then the business owner goes to court. And so the judges, however, were not granting a lot of the business owners' suits. And what he found was the reason is because of many of these losses had already been compensated by the federal government's program, particularly the PPP loans. And so because they were already compensated, the insurance companies were basically off the hook. The other thing about Professor Thomas, which is really interesting, is he's our Chinese scholar. So Dean Thomas has spent a lot of time in China. We have a very, very rigorous Chinese program with many Chinese students coming here for our master's program. Many of us, including myself, going to China with our own students. This is all before the pandemic, of course. But Dean Thomas continues his work with these Chinese scholars and has written several articles with the Chinese scholars who write in this area. Our next is Professor Chesley, and Professor Chesley teaches property and land use, trust and estates. And this article that she's talking about here has to do with property held by the retirees. So some of you may be familiar in many states, including in Missouri and Kansas, a married couple, and only a married couple, can own property. Value to them, the advantage is that if you own property by the entire lease, so if my husband and I own property, and I then incur significant debt, the debtor, the creditor, cannot attack that property that's held by the entire lease. So it protects, the non-debtor spouse. So now my husband is protected from the creditors coming after our property held by the entire lease. So it's of significant advantage, right, to married couples in those states that actually use it. Well, what Professor Chesley's writing about is many people now are putting their trust to avoid probate. And so, but interestingly enough, what people don't realize, what many attorneys don't realize, is that if you put property by the entireties, held by the entireties in a trust, you might lose some of that protection. And so that's what she's writing about here. So her article really is focused on attorneys, saying to them, you need to be careful about this. Yes, your clients want to put their property in trust, again, to avoid probate, but this is the consequence that could happen. So that's what Professor Chesley is doing. Professor Johnson is also one of our new professors, and he's particularly interested in local government law, so state and local government. And he is looking at, again, whether or not state and local governments make decisions based on lack of information, how they make these decisions, and then are they making these decisions within the authority that they're given by the laws? Because state and local governments only have power given to them by the legislature. And so his question is, are they exceeding that? How are they working in this way? Research is really important. Again, so much of this is very topical, right? And it's important. As I'm sure you know, there's a lot of now distrust, mistrust in government. I don't believe the government, this kind of thing, this narrative. So he's really looking to see, okay, is there a rational basis for this, or, is it coming from someplace else? So that's his particular work.
Question about that. That hinges or that puts the executive part, which is being studied, the legislative part, and how does the court, as the third one, can be an arbiter there?
Well, and that's what the courts do. That's the reason that we have this separation of powers. And one of our other faculty members, I'm going to talk about, writes about that. And I'll tell you a little bit about what he's writing, again, along those same lines. So Del Wright, he is also one of our business professors and one of our tax professors. He writes in an area that I have found utterly confusing, and that is cryptocurrency. I would have the hardest time figuring out exactly what this is. My area, because again, I teach family law. And actually, in a lot of divorces now, we have, this cryptocurrency. So in the journal that I edit, we just published an article for our readers, our lawyers, about, what does this mean? How do we value this? And so Adele is our resident expert on Bitcoin and cryptocurrency. And his contribution to the literature has been to make this, for instance, a short and happy guide. Okay. It's actually cryptocurrency understanding, which is a huge benefit to lawyers and general public as well. Barbara Glesner-Fines is our Dean Emerita. So she just left our deanship in July. And her area is also family law. It's family law and professional responsibility or ethics. And she has just written a very fascinating article about attorneys who have experience. And family law attorneys in general have more malpractice claims, have more complaints in bar associations and other areas of the law, in part because our clients are generally not happy. When it's over, it doesn't matter, win or lose, it's not happy time. And so, but what she found was so interesting. The other reason that family law attorneys often have a lot of claims, there are a lot of lawyers who don't specialize in family law, but who actually practice family law as part of their kind of general practice. We call them the dabblers. And the dabblers have a lot of complaints against them because they really are not adequately prepared to practice family law. So, but her piece is about experience. And is experience always a good thing? And what she found through a number of cases, one involving an attorney in Kansas who was disbarred, is that sometimes experienced attorneys rely too much on routine, on what they think they know that was true before, that is no longer true, because again, keeping up, with the law is a challenge, especially in areas like family law, which is constantly evolving. We have new cases, we have new law. When you think about family law, there's no area of the law that's more culturally bound than family law. And so now we have all kinds of things about, transgender, LGBTQ, marriage equality, all of these things constantly, changing, being challenged, etc. So that's really fascinating. And again, directed towards attorneys, like, don't be too smug, right? Because these are the kinds of things that could happen. Dean Glesner-Fines is also a nationally recognized expert on the development of law students' professional identity. So the ABA, the American Bar Association, is our accrediting institution, and they are now requiring us to focus with our students on what does it mean to be a lawyer, what does it mean to be professional, it's about ethics. And so she is a leading expert in that area, and also in legal educational assessment. So many of you were long familiar with this idea of assessment. What are we teaching? Are we teaching it accurately? Are we getting the results that we want? Well, this was kind of new to law professors. This whole area, again, the ABA says you've got to start assessing what's going on with your legal education. Law professors' response was, well, I'm training my students to be lawyers to pass the bar exam. They're passing the bar exam. End of question. Actually not. And so Dean Glesner-Fines really is a national expert on this area, and really goes all over the country talking about is Irma Russell. And Irma is one of our environmental law professors. And she and the next professor you're going to see, John Ragsdale, are particularly interested in this idea of sustainability. So we all hear that, what does it mean to have a sustainable culture with our climate change, et cetera. So she's written a book published by the ABA called Sustainability Essentials. And basically, it's kind of a new legal perspective that asks lawyers and law students, how can you contribute to sustainability? And again, with paying attention to what clients want, very mindful, okay? What are the practices that will basically, increase sustainability? And they talk about it from, environmentally, socially, and economically sustainable. So again, real cutting edge kind of scholarship that she and also Professor Ragsdale are involved. So Professor Ragsdale is our environmental professor also, but he's also interested. He teaches law in the American Indian, he water law, and he's quite prolific. He is working on a huge project now having to do with sustainability over a very long period of time. It goes all the way back, to basically, prehistoric times, all the way to now and to the future. What does this mean? How do we deal with these issues that come up like climate change? A particular interest, I thought, for us here is that he has completed an incredible portfolio of research since his retirement. He continued to work and has done an incredible amount of work in addition to teaching. So he still teaches for us as well. Most of our Emerita faculty actually do teach. It's really hard to get rid of us. And so we're still hanging there. We really do like each other and our students. So Lou Mulligan is our new dean. He came to us in July, and he came from KU, where he was in the provost office. And Lou is an expert on civil procedure, which is basically the rules of how lawsuits proceed, and particularly in the federal area. So one of the things that he's writing about now, which is very interesting, again, very topical, has to do with when you have a state and there's an elected governor and there's an elected attorney general, and the attorney general is the spokesperson in the court for the state. So I'm the attorney general, I'm representing the state. So that's why you'll see, for instance, in a lot of abortion cases, you'll see, it's basically starts off with the attorney general's name, okay? Because that's the person who's bringing basically the lawsuit. But what's happened recently is, so you might have, for instance, a Democratic attorney general who brings the lawsuit, but then you might have a Republican lawmaker who disagrees with it and doesn't think that that's the right approach. And so the Republican lawmaker, and again, it could happen either way, right, Democrat or Republican, says, well, I'm going to go to court and I represent people. And so I'm going to court and I'm going to take the opposite. And the question is that allowed under the rules? Can you do that? Can you have more than one single elected individual representing the state's interest? And what he says is, and we call that, he describes it as self-intervention. So now we've got this legislature, intervening. And basically, he says that the text, history, and practice of the federal rules do not allow this to happen, okay? So again, it will eventually get to the Supreme Court, but Dean Mulligan, no doubt his work will be cited by people who are saying, no, it's the attorney general, like it or not. And in some states, you may be aware, I live in Kansas, we have a Democratic governor and we have a Republican attorney general. So again, presents all kinds of issues having to do with self-intervention. And again, people will rely on this scholarship at the Supreme Court. There's no question about it. It's also the author of the Federal Rules of Civil Procedure, which is the premier guide, he and co-author, to the rules of civil procedure. Again, a nationally known scholar. Tony Lupino is our individual who does probably the most interdisciplinary work. Tony is very involved at the Rainier Center Institute at the Block School. So Tony is about entrepreneurship and innovation. He directs our program. Tony is grants from the Kauffman Foundation for his work in entrepreneurship, both in social entrepreneurship and also business. particularly in entrepreneurship education for lawyers and for business students. John OBrien is probably one of our most famous professors for his work on the death penalty and on the Innocence Project. So when you see in the paper recently some person being released as a result of being wrongly convicted, chances are good that Sean has had something to do with it. Okay? So Sean is directly responsible for litigation that resulted in the correction of 20 unconstitutional sentences of children from death row throughout the country. And then he began his work at the law school with the Midwest Innocence Project, which again looks at mostly newly discovered evidence, DNA evidence, which may not have been available at the time of the conviction. And students are responsible, again, for overturning the conviction of these wrongfully convicted individuals. And so his scholarship then, not surprisingly, focuses on wrongful convictions. And he's very interested in the intersection between human development, social work, and mental health. Because, of course, many of the people who are incarcerated, have a history that would relate to those particular topics. Ellen Suni, again, is one of our Dean Emerita. And Ellen, again, is also still very active. After Ellen retired from the deanship, she was one of our criminal law professors. She discovered that although Missouri has an expungement statute, which allows people to get their record expunged under very limited circumstances, and then allows them, for instance, better access to jobs, housing, et cetera, because they don't have criminal records, that in fact, many people were not taking advantage of this. And a lot of it was because of lack of knowledge and assistance, because even though we have an expungement statute, it's very limited. And it's very convoluted and complex. It's hard to navigate. And so basically what she did is she began this project called the Clear My Record. And I have their website down here if you're interested. It's a fascinating project. And so she now runs a clinic at the law school with our students, and she help individuals, low-income individuals, to seek expungement of their records. So again, a lot of, just like Sean and others, a lot of community engagement. That's their scholarship, is to be public facing, helping the community out through their scholarship. Nancy Levitt is also one of our associate deans. She's the associate dean for faculty. Nancy wrote a book called Happy Lawyer, which was actually required reading for many first-year law students when it was first published. And it's really about, it's a series of vignettes from lawyers about what does make a lawyer happy. And as I'm sure you know, many lawyers are not happy in the profession. And so her idea was, let's focus on what are the things that are positive. And of course, a lot of work-life balance at the center of her work. Nancy is also going to be publishing a book with Simon & Schuster, again, popular media. And her work here focuses on women in the workplace. Why have women not done well in the workplace? Women have advanced in many areas, but they still they represent very few CEOs, very few higher management. And so why is that? And so her co-authors have looked at what are the factors that keep women from advancing. And part of it is basically what she calls, this unproductive competition. The competition that exists primarily in corporate. That's what she's focused on. How do women react to that, to the extent that they're still there, as opposed to leaving, which many women do because of that environment. Book, Fair Shake, I think is going to be very popular when it is published here by Simon & Schuster next year. Doug Linder, some of you may know this, and I think for emeriti faculty, you might find this fascinating. Doug has a website called Famous Trials, and it is absolutely fascinating. So it is full of original essays, trial transcript exhibits, all the way back from the trial of Aristotle, Plato, all the way to George Floyd. There are, I don't know how many, last count, of websites, and he has all this information about all these trials, famous trials throughout history. He's very often interviewed on the History Channel and other, similar broadcasts. But if you have a chance, it's again just famoustrials.com. I think you would find it fascinating. That he's doing. Finally, last but hopefully not least, is a scholarship. So my scholarship also, prior to my retirement, was also public facing in the sense that I authored several booklets through the American Academy of Matrimonial Lawyers, which is a national organization of family law attorneys, about 1,600 throughout the country, that focused on advising clients in particular family matters. So I wrote a book on assisted reproduction and adoption. I wrote one on what to do if you are a person who is seeking a divorce and you have a child with special needs. How is that different from another kind of situation? That I'm probably most proud of is one that I wrote with a psychologist who at the time was the preeminent authority on children of divorce. And in this particular book, it's called What Should We Tell the Children? And so this is a book that attorneys give to their clients about how you tell your children about the divorce or the separation. That book itself, the initial publishing was $15,000, and it's now being translated into French and Spanish. That's probably the thing that I'm most proud of in my professional career. I continue to act as the executive editor of the Journal of the American Academy of Matrimonial Lawyers. We publish twice a year. It's an academic journal. I have students, a staff of students that I work with. They edit articles and they also write comments. And basically, it focuses on cutting edge developments in law and policy that have to do with family courts and children primarily, and those who are divorcing. So we publish that from the law school twice a year. That and my teaching and my 9 grandchildren keep me busy in my retirement. So that's what the law faculty is up to. If any of you are interested, most of the recent work of the law faculty can be found at that scale. Okay. Any questions or? All right, very good. Well, thank you so much for your attention. Thank you for letting me brag about my colleagues. And now you know a little bit about it. Let's go.